The family of Angel Naranjo, who is 16, they're suing Clark County and the Southern Nevada Water Authority right now. Naranjo died on July 13th of 2023 when he was riding a motorized mini bike on the wash trail near Pecos and Lake Mead Boulevard and hit a loose cable that caused him to be thrown off that bike. The lawsuit accuses the county and also the Water Authority of not properly maintaining that trail and having improper lighting, which meant that Naranjo couldn't see that cable. Well, what are the laws when it comes to local governments maintaining public property? And what rights do you have as a resident when it comes to being injured on public trails and public property? Here to discuss all of that and more, we have attorney Matthew Hoffmann with us from Battle-Born Injury Lawyers. Thank you as always for joining us. And I'm glad that we kind of spelled out what is at play here. We're talking about public land and we're talking about a teen who sadly lost his life when he didn't see a cable on that land.
Yeah, and it's a trail, right? A public trail. It's just a horrible tragedy. I remember when this happened. So the lawsuit gets filed. They name Clark County, Southern Nevada Water Authority. That's basically the two entities responsible for the ownership of it and the maintenance of it. Okay. And it is a trail, next to a wash, which has these cables up. And apparently one of the cables was down, and the cable was somehow in the roadway. The lighting was poor, and this poor boy, hit it on his mini bike and went flying. The general rule when it comes to whatever it's city, county, the state of Nevada, what have you, you're getting into what's called sovereign immunity. Sovereign immunity is like the oldest law in the land. It comes from England. It's you can't sue the king, you can't sue the sovereign. In some states, it's strict. Like you cannot sue, the state, political subdivisions, etc. In other states, they have no limit, and in Nevada, we have basically a modified sovereign immunity. So you can sue the state, you can sue the political subdivisions, cities, counties, etc., but you're capped at damages if they're responsible at $200,000. That's the most you can get, no matter how bad or how egregious it was outside of just intentional acts. The bigger issue here is what's called recreational use, and that's what they're going to run into as a big problem with the Water Authority and the county.
And how does recreational use change things?
Yeah, so recreational use, think of Nevada outside of the city of Las Vegas. We have open range, a lot of public land. The BLM owns, 90% of the state. And Nevada wants to encourage outdoor activities and access. So when you think of rural Nevada, you might have all this beautiful BLM land, but to get there, you have to cross public land. Well, we don't want these landowners fearing lawsuits because somebody went on their road, hit a cattle guard, flipped off their bike, what have you. So Nevada has basically a shield, no liability if there's recreational activity on your land. So, for example, that I gave, somebody's using a road to get to go hunting, to go hiking, to go bicycling, mm-hmm. if you're running, all those different activities are all fall under the umbrella of recreational use. And here you have a path, it's owned by the city and the Water Authority or maintained by the Water Authority. It's being used for a recreational activity, albeit a mini bike. Mini bikes are counted in the statute, and something terrible happens. Whoever owns that, county, Water Authority, they are immune. You cannot sue them under recreational use. The only way to get around it is you have to prove that they basically did this intentionally, willfully, and wanted to hurt people, which, I don't see those allegations here, and I don't know how you would ever get there. So absent that, recreational use immunity in Nevada is an absolute bar. So what I expect to happen is that the city and Water Authority will file motions to dismiss, and I think they'll likely get granted. Wow. Yeah.
And yet here we are with this lawsuit that someone filed on their behalf.
Yeah, and I think they're fighting the good fight on this. But there's talk in Carson City of modifying this to make exceptions. Probably not in this situation, but let's say there's private contractors doing work mm-hmm. on public land, and right now they'd arguably be shielded, even if they were completely negligent. But this applies on any public lands owned by anybody, including the city or state. So parks. Right, you get injured on a park, the park swing broke or something, recreational use. You're driving on, like I said, rural Nevada, a cattle guard is out, there's a huge hole in the road and there's no warning signs. Recreational use. There's complete immunity for landowners in these kind of situations. I think that's what they're going to run into here.
Well, I think we all just learned something here, and it's important for us to know because we all use that land at any given time. And so thank you for breaking that down. And of course, that doesn't negate the fact that this poor family is suffering because a 16-year-old is no longer here. So our
It's
thoughts
terrible.
with them as they are dealing with this unimaginable loss. I do want to thank you as always,
Yes.
though, for breaking down the law for us. And if you have any legal questions that you want Matt to answer, please email us at breakingdownthelaw@news3lv.com.